Jacqueline Elaine Jacobs, not present. Andrea Pullings, Ms. Pullings is outside. Jeremy Shelton. Jeremy Tremaine Shelton. Margaret Wilson. Jason Bearden. All right, I have some additional information on Mr. Bearden. We'll discuss that with Mr. Adams. Not call that case. Carlos Gatlin. Leighton House. Mika Johnson. Marshall Flores. Lauren Foley. Grace Fowler. Alicia Harris. Jonathan Keenan. Jonathan James Keenan. Kaden Mitchell. Ashley Smith. Justin Smith. Dustin Lee Smith. Lanaria Miles. Sergio Villarreal. Sergio Arturo Villarreal. Not present. Jason Mays. Robert Gerard or Gerard. Robert Gerard. Thank you, Mr. Chairman. Ralph Hanselka. Desiree Harris. Dylan Hogan. Charles Howard. Shelby Joslin. Michael Musselwhite. Michael Todd Musselwhite. Dylan Ostrich. Leonard Purley. Ishmael Rodriguez. Did you say here? Yes. Jeffrey Viramontes. Alfonso Medina. Alyssa Villarreal. Alyssa Joanne Villarreal. Brandon Robertson. Brandon Eugene Robertson. Dustin Hall. Dusty Rhodes. Dusty Lynn Rhodes. Jan Espino. Is there anyone who's in the courtroom and I've not called your name? Your name, sir? Eric Hoover. Yeah, Mr. Hoover, I called your name. You're number 4. Were you in here at 9 o'clock? That's why. Court starts at 9 o'clock. You understand? So I'm gonna mark off. Do you want me to mark off? Issue a warrant for your arrest? Do you want me to mark that off? Okay. Next time be here at 9 o'clock. Anyone else? All right, counsel, who's ready? Mr. Ashmore, are you ready? Are you? Okay. Do you have any counsel that's ready? No eye contact tells me no one's ready. Ms. Thompson, are you ready? Yes. CR 2277, Brandon Eugene Robertson. Is Mr. Robertson here? All right. Court will have his name called loudly, distinctly 3 times. Failure to appear, court's going to issue a judgment not sign any of these cases. Is that all you have today, Ms. Thompson?
That's it. Yeah.
All right. Have a good day.
All right. Thank you.
Hawkins. Jason Lee Mays, CR 2401. Mr. Mays, Mr. Sawyer is not here, but he has asked Mr. Hawkins to stand in. Have you met Mr. Hawkins? Yes. And do you consent to Mr. Hawkins standing in for Mr. Sawyer today? Yes. Okay. All right. And I show that we're set for pre-trial today. Do you know if there's any contested pre-trial motions, Mr. Hawkins?
There are no contested pre-trial motions. Mr. Sawyer had a conflict this morning. He reports to the owner that he has received the discovery. That he has not had an opportunity to go over it with his client. He's just asking for a pass to the next reset, either a pre-trial or docket call.
Okay. There being no contested pre-trials, the court will set this for docket call. Do you know his availability at all?
I don't judge.
I would look to put him on either June 14th or 16th. We'll just set him for June 14th, and then if that's an issue, you can let us know.
What time on that day you're on?
That'd be 9 a.m. All right, Mr. Mays, we're going to reset you for docket call on June 14th. It'll be between this date and that date that I expect to find out from you whether or not there's going to be a plea agreement or a request for a trial. Okay. So during this time, you're going to discuss that discovery with Mr. Sawyer, and then you're going to evaluate your case against the state's offer. Okay. All right. If you have a reset notice, once you sign and get that yellow copy, then you are free to go, sir. Thank you.
Thank you.
Mr. Stevens.
Alfonso Medina.
Alfonso Medina. This is cause number CR 22112. And Mr. Medina is set for arraignment today. Have you had a chance to go over the indictment?
I have, Your Honor. If may please the court, my client would advise the court that his name spelled correctly. He understands the nature of the consequences of the charges. We'll waive reading of the indictment and enter plea document.
All right, court will find Mr. Medina has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record. Mr. Medina, the court will set you. Are you available on June 14th, Mr. Stevens?
Yes, sir.
All right, court sets Mr. Medina for pre-trial on June 14th at 9 a.m. And Mr. Medina, once you sign the once you sign the notice of appearance and get the yellow copy, I need you to report over here to pre-trial release. There's going to be conditions of bail, conditions of pre-trial release that you're going to have to comply with. This means no drinking alcohol, no committing new offenses, reporting to your pre-trial release officer. They'll go over all those with you. Any violation of any of those could result in the court revoking your bail, finding that insufficient, and putting you back in jail. Okay? I know you don't, but I got to give you fair warning. Okay? So once you sign, get that yellow copy, come over here and see Ms. Burns, and she'll give you more information. Okay? You go. You can come up here and sign right here on this table. Mr. Stevens, get the yellow copy, then you can step right over here.
Judge, I have a list of Villarreal. She didn't answer this, so we're going to try to find her.
Alyssa Villarreal. Also, Mr. Stevens, I'm going to need you to be present for a hearing this afternoon at 1 o'clock. o'clock for one of our inmates on an issue with mental health medications.
I will be here.
Okay.
Is that going to be here at the jail?
It'll be at the jail.
Okay, yeah, I have somebody else to clean anyway, so I plan to be there.
Good.
Thanks, sir.
We're gonna have Dr. Pemberton testifying today regarding his evaluation of the client.
Okay.
His instructions, diagnosis of mental health, and then his suggestions. Get back to the competency.
Thank you, Judge. See you this afternoon. I'm gonna try to get out of this little rehab.
Mr. White, you ready? Jan Espino. This is cause numbers CR 21, 113, 114, and 115. All right, Mr. Espino is set for docket call today, Mr. White.
Your Honor, approach bench.
All right, Mr. Espino, the court's going to set you for an additional docket call on Tuesday, July 19th. Be sure that you're still checking into your pre-trial release officer. Fine, okay?
Here, use that one. You keep it. Set it right there.
Give me some- Margaret Wilson. This is cause number CR 17-121, State of Texas versus Margaret Wilson. Ms. Wilson, I see here that there is a request to extend your probationary period for an additional 8 months. Right now, you're set to expire in 5 days, May 15th, 2022. And the request is to extend you until January 15th, 2023. Why do we need to extend your probation?
Someone able to work this time, I got behind on my fees.
Do you believe if I extend your probation for an additional 8 months, that would allow you to complete all of your conditions successfully?
Yes, sir.
All right. Is this your request? Ms. Wilson, has anyone threatened, forced, or pressured you to make you feel like you had to extend your probation period?
No, it's registration.
Okay. All right. Court will approve the extension of Ms. Wilson's probationary period for an additional 8 months. Her new expiration date is January 15th, 2023, and the court will order that she also be required to pay probation fees and your analysis fees during the period of this time. All right, Ms. Wilson, if you come forward and see the probation officer, we'll get you a copy of that. You're free to go. Mr. Weiner, are you ready?
Yes, Your Honor.
Who are you ready on?
Both of mine. Dustin Hall or Dusty Rhodes is not present.
Okay. Dustin Lee Hall, CR 21385. All right, Mr. Hall is set for docket call.
Yes, Your Honor, I've spoken with the state. It's kind of a unique case. It's a relatively large amount of dough, but my client doesn't have any substantial criminal history. I've provided some information to the state about the passenger in the vehicle. We've made some pretty substantial progress, real close to getting it resolved via plea bargain. And so whether the court would be willing to give us a docket call or just put it on jury selection with the understanding the state would withdraw the offer, we just need a little more time. That's where we're at.
Any objection from the state?
No, Your Honor, we have made substantial progress. Some information is helping me reevaluate this and see things weren't as light that I was seeing previously, so I think we will be.
All right. Of course, not aware of Mr. Hall having any issues on pretrial release, so I'll grant him this request for an additional reset. So are you available on June 14th or 16th?
That is a week that I'm out, Judge.
About,
The 28th, you've set me on the 28th, maybe?
that's evidentiary day.
Okay, I'm sorry.
Let's,
Making up for all those COVID vacations.
what about June 2nd? It's not quite 30 days, but
I'm actually gone that week too. I'm glad I made my joke timely. Sorry.
you want to come back on the dreaded July 5th?
I will be here on July 5th, Judge.
All right, we'll set Mr. Hall then for docket call on July 5th at 9 a.m. Once you sign and get the yellow copy, Mr. Hall, you're free to go.
Thank you, sir.
You're welcome.
He's not present, Judge.
Dusty Lynn Rhodes, CR 1326. Mr. Rhodes' name was called at 9 a.m. He was not present. Court will have his name called loudly distinctly 3 times in the hallway. If he fails to appear, the court will issue a judgment not signing of these cases.
That's all I have, Judge. Might be excused.
Yes, Mr.
Good to see you,
Good to see you. Take your meeting. You still working, Mr. Schmidt?
Judge, I can make some comments.
Sure. Sure. Tell me who you want to announce on.
We are working on your
So we can? Okay, good. So first one I'd like to call is Mr. Hanselka. Asked to approach with
CR 21-169-170, Ralph John Hanselka. Mr. Hanselka, if you'll come to the podium. You want to approach. All right, Mr. Hanselka, the court is going to set you for docket call on Thursday, June 16th at 9 a.m. Once you sign and get your notice of appearance, you're free to go.
That's very fun. Yeah, June 16th.
Green, your client here. You're one of them that wasn't on there.
Ishmael Rodriguez.
Ishmael Rodriguez, CR 21368. Mr. Rodriguez, plea today.
Judge, we received an offer that we're going to accept. It's for time. Mr. Rodriguez needs to get his affairs in order, and we're going to set it for a plea. We can come back on that 16th if the court would like.
All right, court will set Mr. Rodriguez to enter his plea before the court on June 16th. You want that at 1:30? You said that's gonna be for time.
Yes, sir. That's fine. 1:30.
All right, so it'll be at 1:30, Mr. Rodriguez. And once you sign and get your notice of appearance, you're free to go.
So that day, there.
Desiree Harris, if you like.
Desiree Harris, CR 2223. Ms. Harris is set for pretrial today.
That's correct, Judge. We don't have any contested pretrial at this time. We received an offer from the state this morning. And I'll relay that to my client, ask to be set for docket call on that.
All right, court sets Ms. Harris in for docket call on June 16th at 9 a.m. Once you get your notice of appearance, you're free to go, Ms. Harris.
I'm sorry. You need to call me because we got some business stuff that I want to wrap it up on the 16th. Okay. You'll want to too, won't you? Or email. Cool. Yeah, give it to Mr. Waddell. Judge, I think all the rest of mine are going to be plea. We don't need paperwork, so. we can, oh, no, that's not correct. I have Mr. Howard, Charles Howard.
Charles Justin Howard, CR 2176 386. Mr. Mr. Howard set for docket call.
That's correct, Judge. We received note from the state, Mr. Howard, at this time would reject the offer and announce ready for trial in both cases.
All right, the court sets Mr. Howard for jury selection beginning on Monday, June 6th. Mr. Howard, you'll need to appear at the courthouse 8:30 on the second floor. My staff will be down there and they'll coordinate with you on whether your case is going to trial or not. It's not going to go to trial in the first setting in June. So you'll appear, you'll have a notice of appearance, you'll sign it, she'll give you the new date, and then you'll continue to do that until your case is reached for trial, okay?
Yes, sir.
Okay. Thank you, Mr. Schmidt. Ms. Pullings, why don't you come over here and meet with the probation officers, and then I'm going to call your case after that, okay? Yes, sir, Mr. Schmidt. Purley? Leonard Purley, CR 21-234. Mr. Purley set for docket call.
That's correct, Judge. We've come to a resolution with the state and require Mr. Purley to pay some restitution. We expect that once the restitution is paid, that the state is going to dismiss the charges. We can have that done prior to the June 16th date. We asked to be set for a resolution on June 16th.
All right, I also show that Mr. Purley is delinquent $260 on his pretrial release. Is that going to be taken into account with the restitution?
I'll have that next quarter. Try to get it all paid up before that next quarter date. Come back.
All right, court will set Mr. Purley then for docket call on June 16th, 9 a.m.
Some folks, you don't ever have to come back to this place. If you get into it.
Mr. Green, are you ready?
Johnny Smith was actually justice.
All right, so you're ready on Ashley Smith. Is there any relation between those two?
No.
Ashley Smith, 2021-494, CR 21341. Show that Ms. Smith is set for a docket call in each case.
Yes, Judge. When we were here last, I had filed a motion to view the scene of the blood draw. Mr. Woodwick and I are in the process of trying to locate where that was because it's not expressed in the discovery provided to the state from the arresting officer. Doesn't it to me? So we're still working on that. If we could set that, I guess that June 16th date, or if there's another day.
I have June 14th or 16th right now.
14th, I'm setting some stuff in Athens. So 16th at 9 a.m. Is that right?
That's correct. Court will reset Ms. Smith by agreement to docket call June 16th at 9 a.m. And before you go, I may have an issue with pre-trial release.
And Judge, I know what it is. I visited with Mr. Waddell about it this morning.
Interlock device.
The interlock, and I think that's where the confusion is that she has had a lengthy suspension based on this. She is not, because of the fact that when we anticipate resolving this, there will be another suspension. She is not renewed her driver's license. She's not driving. That's why she doesn't have an interlock. Mr. Waddell did point out to her yesterday, and Mr. Waddell discussed this morning. We were not aware that the court also required, if you did have an interlock, that you had to have some device besides the interlock. We visited this morning. She's going to work on getting that issue resolved.
Okay. So you understand what's required of you, Ms. Smith? Okay. All right. Court will see you back on June 16th. Once you get the notice of appearance, you're free to go. Ms. Pullings.
Smith's case.
Well, I called him at 9. He wasn't here. So
Oh, okay.
yeah, I've already called him. That's how I knew he wasn't here. So yeah, once we get through, I'll call his name 3 times and then we'll issue a judgment on side.
Excuse me.
You may. Good to see you. Ms. Pullings, I've ordered you to do a UA, so you're going to have to comply with Officer Matura. You're going to have to. It's either that or it's a refusal and you go to jail today for violation of pretrial release or probation.
Bitch, I just had a baby, like I can't.
I understand. We're going to give you time. If it's just a matter of drinking water and needing time, that's fine. You can sit here and we can wait. I'm not worried about that. But when you give the sample, she's going to be there to make sure that you're not falsifying. Okay. All right. So drink water and then let Officer Matura know when you're ready. Mr. Schmidt, you ready?
Doing Ostrich.
Dylan Ray Ostrich, CR 20223. Mr. Ostrich, set for pretrial.
That's correct, Judge. We've received some additional discovery from the state. I think we got notice as of last week. They're still seeking more discovery. In addition to that, I've gone through what I have, and I have a list of other items that I'm going to send this HISA that should exist that we expect. Hopefully, they'll locate. So, we're requesting another future also.
I was going to say, Judge, that's correct. We have this investigation of different jurisdiction. We have requested multiple times for discovery, and the first time we did not receive a response. 2 weeks ago, we received a response. They were working on it, but no delivery date. So we're kind of, trying to work this out and trying to get it.
All right, court will reset Mr. Ostrich for an additional pretrial on June 16th at 9 a.m.
Judge, if I might, could I request the court set him for a later date than that? I do know that we've been struggling, and I know the DA's office as well has been working and struggling, trying to get these other jurisdictions to comply with these discovery requests. We had similar issues in the companion case that are ultimately never resolved. So I understand the court wants to keep it set, but it's not going to happen by June 16th. I can definitively say that for a change.
So on the co-defendant case, state never got the discovery the same discovery that you're requesting in this case.
That's correct.
We physically drove to the other jurisdiction, which is a couple hours away, picked up discs, but when we got them back to our office, they wouldn't play or they weren't probably, or I don't know what the issue was, but they wouldn't play. And what we're waiting on is replacement discs plus whatever else Mr. Schmidt is requesting. He said he don't have to do for an additional.
Co-defendant case
That one is
Still
still
busy.
dismissed.
and dismissed.
Curry dismissed that case. It's the same kind of evidence, but it's different application. But in this case, I do know that from what I've reviewed in discovery, there are certain items referenced by an investigating officer that I don't have. So I know that they were collected or produced. I just know this DA's office doesn't have it.
Got July 5th, 7th, 19th, 21st, 5th, 7th, 19th, 5th.
Yes, sir.
All right, court will reset Mr. Ostrich for July 5th for pretrial and status on the additional discovery. Mr. Schmidt, do you have any others you're ready on?
It's coming from Tyler. I spoke with him. The last notice he had was for 1:30, so he thought it was 1:30.
Was he in jail before this? Okay. Mr. Manning, are you ready? Lanaria Miles, CR 2239. Miles is set for pretrial today.
Yes, Judge, we received the paper discovery and gone over that. However, we are still in need of the DVD, body cam, and in-car footage. We request additional pretrial for us to get that and review it.
Has that been produced, just not picked up, or is it still in the process of being produced?
Judge, I received an email from Ms. Melton last Tuesday or Wednesday saying there's had some DVDs ready. I haven't got either picked up at this time, maybe in that batch, but I haven't received them previously.
All right, you available? You want June 14th, correct?
Thursday, the 16th.
Thursday the 16th.
Yes, Judge.
I thought one of you was Tuesday, one of you was Thursday.
He's Tuesday.
He's been setting everything for Thursday.
Whenever the court would like to set.
All right, June 16th. All right, Ms. Miles, court resets you for June 16th at 9 a.m. Once you sign and get the yellow copy, you're free to go. Perhaps you'll have a lot of cases to stand in on Thursday. I think he's clearing off his Tuesday.
I've been in contact with Mr. Villarreal and members of his family, but have been unable to ascertain his location this morning. I'll continue trying to get him here. Judge, I will be around this morning, so if you want to call me when I hit period, I'll scoot back over here.
Sergio Arturo Villarreal. Name was called at 9 AM, was not present. His name's been called again. Court will call his name at the conclusion of the docket loudly to stand 3 times in the courthouse. If no response, court will issue a judgment nasi and alias capus. It's for the benefit of his bond. Thank you, Mr. Manning. Calvin Kritz, CR 22-9. Mr. Kritz, you've been charged with a state jail felony offense of possession of controlled substance, penalty group 1, less than 1 gram. That does carry a range of punishment if convicted and sentenced, not less than 6 months or more than 2 years in state jail prison. Today you are set for arraignment. Do you intend to hire an attorney to represent you?
Sir, I just talked to Mr. Smith.
Okay.
Fowler. I get the money up for it right now.
If I were to reset your case, do you believe that would give you enough time to get your money together to hire Mr. Schmidt to represent you?
Yes, sir.
And I typically only do about 30 days. You believe that you can get that done in 30 days? Right, but do you believe you can get it done? Do you? But I understand what you're saying. That's all you got. But do you believe you can get that done?
Yes, sir.
Okay. All right. The court's going to reset you until Thursday, June 16th. Deputy's going to bring you a form. I need you to sign that. We're going to give you the yellow copy, and then I want you to come meet with these officers over here about pretrial release. There's going to be conditions of pretrial release that you have to sign that will be attached to your bail in this case. It means if you violate any of those, the court could revoke your bail. Here, they'll give you more information. Mr. Hoover, CR 2268. All right, Mr. Hoover, today you are set for arraignment on the state jail felony charge of illegal dumping. And as you heard me tell Mr. Kritz, the range of punishment for state jail felony, if convicted and sentenced, is not less than 6 months or more than 2 years in prison. Do you intend to hire an attorney to represent you in this case? You believe that they gave you a court-appointed attorney? If they gave you a court-appointed attorney, I would have it on my docket here, and that court-appointed attorney would be here with you. Who is your court-appointed attorney? If you believe they gave you a court-appointed attorney, and they is me, just so we're clear, wouldn't you know who your court-appointed attorney is? And when do you think they gave you a court-appointed attorney? Today? All right, go ahead and have a seat. I don't think that's been done yet. So you met with Ms. Tabraham today? You met with Ms. Tabraham today? Okay, all right, have a seat. I'll double check. Hoover? Yes, that's Mr. Hoover right there. Okay. Thank you.
Jacqueline Jacobs.
CR 2255. Ms. Jacobs, the state has filed a motion to revoke in your probation case. Do you intend to hire an attorney to represent you on that? Okay. Do you know how long you need for the court to reset your case so you can hire an attorney? A couple of weeks. When did you know that you had a motion to revoke?
Probably, I didn't really know because I went to like I had COVID and I was really sick, so I left from rehab. But I did end up going back 17 days later.
Well, I don't want to, let's don't get in
I
on,
don't know like how.
that's what you're going to,
I mean, like, whatever.
this is what I'm going to do, Ms. Jacobs. I'm going to reset you until, you said a couple of weeks. I'm going to reset you until June 2nd. I'm going to give you a chance to hire the attorney that you said you're going to hire, okay? So June 2nd, once you sign and get this yellow copy, then I want you to come over here and meet with probation. You ready, Mr. Hoover? Mr. Hoover? CR 2268. Mr. Manning, I believe you were appointed this morning, is that correct?
That's correct, Judge.
Mr. Hoover is set for arraignment. Have you had a chance to review the indictment with Mr. Hoover?
We have, Judge. He understands the charge against him. He understands the range of punishment. His name is spelled correctly, and at this time, we plead not guilty. And if we can request June 16th, 9 a.m. docket.
All right, the court will find that Mr. Hoover has waived the formal requirements of arraignment. The court will set Mr. Hoover for pretrial hearing on June 16th at 9 a.m. Mr. Hoover, there are going to be conditions of pretrial release that you must sign and you must abide by. If you violate any of the conditions of your pretrial release, the court can revoke your bail in this case and put you back in jail, okay? So you're going to sign this notice of appearance. Mr. Manning is going to give you the yellow copy. After that time, I want you to come over here and meet with the pretrial release officers. Mr. Manning, do you have a chance to talk to Mr. Schmidt about the 14th, 16th? Is Jeremy Shelton here? Deputy Commissioner. This. Amanda French, CR 2162. This is sanctioned. If you want to do it, it's up to you. All right, this is a sanctions court hearing for Ms. French. Ms. French, I show here that you were removed from the City of First Monday Community Service Restitution Program. That means you can't go back to First Monday and work community service. And that's one of the best community service restitution programs we have in this whole county for people who are probationers who need to do a lot of hours like you. And you're delinquent over 50 hours and you can get what, 40? 40 on First Monday? You can get 50 hours of probation. You can get 50 hours of probation restitution at First Monday. You can do it all at once. You can do it a couple of days. It's a great program, but you've been kicked out of it because you're arguing. Same reason you've lost jobs, because you're arguing. The same thing you did in this courtroom. When I pled you out, put you on probation, you argued with me. Argue, argue, argue. You know where you don't argue? In the jail. That's where you're going. That's where you're going. And you can sit there, they'll let you argue all day in the jail in your cell by yourself. That's where you're going to end up if you don't stop. And I can't make myself more clear. And I hope you're listening, because I'm not going to have any sympathy towards you if you don't do what you're supposed to do. That's the reality. That's the hard and fast truth. I'm going to give you one more chance. One more. And that's it. I've told Officer Burns here that any violation, any pushback, any problems, any arguing, just file a revocation on you and bring you back to court. I'll hear the evidence of these violations, and if I find there's enough evidence, I will revoke you. You're on deferred for a Class A deadly conduct. You're looking at up to 365 days in jail. You have kids, don't you? How old are your kids?
My children are 18, 16, and 10.
18, 16, and 10. Do they need their mother?
Very much so.
What are you going to do when they need you and you can't be there for them because you're sitting in jail for 1 year? You don't have to answer. I want you to be thinking about this. What are you going to tell them when they need you, especially your 10-year-old? What are you going to do? They say, Mom, I needed you. You weren't there. And I don't want to hear it. I want to see it.
I think you might.
I don't. I'm telling you right now, I don't want to hear it. I don't want to hear it. I want to see it. I want to see you go back to probation. And the next thing I want to see about you is a piece of paper they put on my desk that says, dismiss Ms. French's probation. She's done everything that she's supposed to do. She's done her community service. She's paid. She's not arguing. She's doing what she's supposed to be doing. And she is done. I would even let you off early if you got everything done. That's all I want to see is you do what you're supposed to do, what you told me you're going to do. I'm not here to argue. That's why I took this job. I was down there at those tables and I argued for years and years and years. I don't argue anymore. And it's a lot nicer. Life is a lot nicer when you're not arguing and fighting with people. And I'm not going to argue and fight with you. This is what I'm going to do. I'm going to give you an opportunity. You can take it or you can leave it. It's up to you. I don't care. As a sanction, I want to put you in trauma group counseling. And I want you to go sit with my counselor and I want you to talk with him about the issues going on in your life that are causing you to have the same reoccurring problem. That's all I want you to do. That's the only thing I'm going to do. I'm not going to ask you to go to jail. I'm not going to put you in jail as a sanction. I'm not going to up your community service. I'm not going to add anything more to it other than go talk to this counselor who is trained about your problems and let him help you so that we can get you where you need to go. That's all that I want. Okay. So if you'll agree to that, I'll sign the order. We'll put you in the program. You go get the help that you need. Take it, lie to your life. And let's get on. Let's get to a better place in your life.
Yes, sir, thank you.
All right. All right, I'm going to go ahead and sign this amendment to your conditions of community supervision. And then I want you to come back here and meet with Officer Mature, Officer Burns here, and they'll give you more information, okay? I don't know. Close enough. It's deferred right now. It is deferred. It could be a revoke at any time. Mr. Adams, are you ready?
Yes, sir.
Who are you ready on? Everyone? Let's, Carlos Gatlin. Mr. Gatlin, if you'll come forward, sir. CR 21288. Mr. Gatlin is set for docket call.
Yes, Your Honor. Last time that we were here for Mr. Gatlin, there was an issue that I had regarding some video footage, it's dash cam footage. And we discussed that. Of course, the state agreed to give us a fresh copy. I visited with Mr. Woodwike about this issue. Apparently there is some technical difficulty specific and special to this particular.
If I may, Judge, for whatever reason, the original disc will open, but whenever copy ends, it does not, the copy does not, for whatever reason. So what I proposed to Mr. Adam, we're just now finding this out. If you will provide us with a USB, pull the original file off the disc, digital copy that's not on the CD, it's still not copy. Whatever reason, we cannot figure out. So if we can have another resets, we can get that figured out. So we can have the discovery technology is great.
And that's fine with me, Your Honor. The reason I'm so hot about this video footage is because the allegation for probable cause for the stop was that Mr. Gatlin's rear license plate lights were not properly illuminated. There is what I perceive to be a still photograph taken from the video footage in question that I don't have, that I think shows that it was properly illuminated. If I could have this video footage, this will clear up for me whether or not I need to file a motion to suppress.
Okay.
And Mr. Gatlin lives in Louisiana, so if the court could give us as much time as possible for him to make that turnaround for his financial costs.
It is at the court's convenience. Mr. Captain's round is fine.
All right, let's see, Mr. Adams, you got your schedule handy. June 14th or 16th.
I'm on the morning of the 14th, 16th, I'm gonna be at Rusty Dungeon.
14th.
Yes, sir.
All right, Mr. Gatlin, court will reset you for docket call on June 14th. And Mr. Adams, due to where he lives, I would be, for purposes of, well, it's docket call. I was thinking it was pre-trial. I was going to say he could appear via Zoom, but we'll continue in person. I was thinking it might have been, if it would have been a pre-trial, I would let him appear via Zoom. So, all right, so we'll see you back on June 14th, Mr. Gatlin. Once you sign and get the yellow copy, you're free to go, sir. Leighton House, CR 21360. All right, Mr. House, show that you want to enter into a plea agreement with the court, before the court with the state. Is that correct? All right, Mr. House, if you'll raise your right hand, I'm going to place you under oath. Mr. House, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you may put your hand down. Is your name Leighton Kane House? And Mr. House, are you a United States citizen? Do you read, write, speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Mitch Adams. Are you pleased with his representation of you? Do you feel like you've had enough time to discuss your case with him, have all of your legal questions answered? Is there anything about this paperwork that you've reviewed and signed today that you do not understand? Mr. Adams, do you believe Mr. House to be competent?
He's competent, Your Honor.
And have you explained to him his legal rights?
I have, Your Honor.
Do you believe he understands them?
He does, Your Honor.
I see here that the plea agreement is Mr. House is going to plead guilty to the offense of driving while intoxicated, third or more. The offer and agreement is upon that plea, that punishment be assessed at 10 years confinement in the Texas Department of Criminal Justice, with that being suspended and probated for 6 years plus a fine, a restitution, court costs, reimbursement fees, and the state would be disposing of a possession of marijuana case. Is that your understanding, Mr. Adams?
It is, Your Honor.
That's your understanding as well, Mr. House? All right, Mr. House, a driving while intoxicated, third or more offense for which you've been indicted is a third-degree felony, and a third-degree felony does carry a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice. That means any sentence that's imposed in this case cannot exceed 10 years or be less than 2 years. Based on the plea agreement, the sentence being assessed will be the maximum 10 years confinement in TDC. Do you understand that? Understand that if the court approves this plea agreement and you go on probation, if you violate your probation, the state can file a motion to revoke, bring you back before the court. They can accuse you of violating that probation. And if the evidence proves that, the court could revoke your community supervision and impose that 10-year sentence. Understanding all of those things, do you still wish to go forward? All right, Mr. House, how do you plead to driving while intoxicated, third or more offense? Are you pleading guilty to that offense because you have committed that crime? Has anyone threatened, forced, or pressured you to plead guilty here today? Mr. Adams, any objection to the state's evidence?
No objection is marked an offer, Your Honor.
All right, court will accept the defendant's plea of guilt. The court takes judicial notice of the defendant's judicial confession, and the state admits State's Exhibit 1. Anything further from the state?
No, Your Honor, we rest.
From the defense?
No, Your Honor, we rest and close.
All right, court will review the evidence. All right, the court's reviewed the evidence, and I do find sufficient evidence to convict Mr. House of this offense. The court will follow the plea agreement that he's reached with the state. Court hereby convicts Leighton Kane House of driving while intoxicated, third or more offense. Court assesses his punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. Court will suspend that sentence, place Mr. House on 6 years community supervision. Court orders him to pay a $2,500 fine, $60 restitution, $290 court cost, $860 in reimbursement fees. Court also dismisses under section 1245, possession of marijuana less than 2 ounces, DA 2021-1005. All right, Mr. House. On your previous DWIs, did you get probation or did you just do jail time? Got jail time. Did you do probation first on either one of them? Probation on your first one, jail time on your second one. So you've had probation and you've had jail, and neither one of those have stopped you from committing a new crime. So what's it going to take? Killing somebody? It's not. I mean, you're lucky that you didn't head on someone that night and kill them. Luckily for you, there was a concerned motorist who called it in and followed you and told law enforcement where you were at. Could have saved your life. Could have saved the lives of anyone around you. So what's it going to take, Mr. House? 10 years in prison? Well, I would rather give you 10 years in prison than you kill somebody. That's what I would rather do. The state believes that you're a candidate for probation again, so I've approved that. I'm going to give you the opportunity. If you screw it up, it's going to be 10 years in prison. Remember this day. If you screw it up, it'll be 10 years in prison. Mr. House, you're hereby remanded to the custody of the Van Zandt County Community Supervision Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted by the deputy. After that time, I'll meet with the officers over here and they'll give you more information. Hi, Mika Johnson. This is CR 21296. Ms. Johnson, if you will raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So be God. All right, you may put your hand down. You are Taimika Louise Johnson, is that correct? And Ms. Johnson, are you a United States citizen? Do you read, write, speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by Mr. Mitch Adams. Are you pleased with his representation of you? You feel like you've had enough time to discuss your case with him and have all of your legal questions answered? Anything about this paperwork that you've read and signed today that you do not understand, including your conditions of community supervision? Ms. Mr. Adams, do you believe Ms. Johnson's competent today?
She is, Your Honor.
Have you explained to her her legal rights and also the advantages and disadvantages of deferred adjudication plea?
I have, Your Honor, and she understands.
All right, Ms. Johnson, you are charged by indictment with a second-degree felony offense of possession of marijuana greater than 50 pounds but less than 2,000 pounds. A second-degree felony carries a range of punishment of not less than 2 years or more than 20 years confinement in prison and a fine not to exceed $10,000. Do you understand that full range of punishment? I see here that the plea agreement that you've worked out with the state is that you're going to plead guilty to that offense, and the state's going to recommend to the court that I defer a finding of guilt, which means that I do not convict you, but rather defer that and place you on probation for 8 years. Order you to pay a fine, restitution, court costs, and reimbursement fees. And if you successfully complete that, then this case will be dismissed. If you do not successfully complete that, and the state files a motion to adjudicate your guilt, that means a motion to convict you, court could also revoke your community supervision, and I could assess your punishment anywhere up to the maximum 20 years, from 2 to 20. You understand that? Understanding both of those things, do you still wish to go forward with this plea? All right, Ms. Johnson, how do you plead to possession of marijuana greater than 50 pounds, less than 2,000 pounds? Are you pleading guilty to that crime because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty? Court accepts the defendant's plea of guilt. Mr. Adams, any objection to States 1?
No objection, Your Honor.
States 1 is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense, Mr. Adams?
Your Honor, I'll say on Ms. Johnson's behalf, in my visits and conversations with her, I'll be surprised if she does not make probation.
You'll be surprised if she does not make it.
If she does not, that's correct. She's very clear-eyed and sober about this, and I think this is a happenstance of being associated with the wrong people that she no longer associates with. I'll rest and close.
Thank you, Mr. Adams. All right, court has reviewed the evidence, and I find enough evidence to convict Ms. Johnson of this offense. Court will follow the plea agreement reached in this case. Court hereby defers a finding of guilt on the charge of possession of marijuana, 50 pounds to 2,000 pounds, a second-degree felony. Court will place Ms. Johnson on 8 years community supervision. Deferred. Court will order her to pay a $3,000 fine. Court cost of $290, reimbursement fees of $785, $180 restitution for the testing of the marijuana in this case. All right, Ms. Johnson, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Correction Department so they can carry out the terms and conditions of the sentence. I hope that you prove Mr. Adams right. That would be a good thing. All right, go ahead and come forward, and Deputy McLeish here is going to take your fingerprint. After that time, I want you to meet with the probation officers over here. All right, we'll go ahead and take up Mr. Bearden. Cause number CR 21-278, State versus Jason Kobe Bearden. What's the update on Mr. Bearden?
Your Honor, he is still in the program. Oh, he graduated.
Oh, there he is. Mr. Bearden, I did not know you were here.
He arrived a short while ago.
Okay,
He was dependent upon the chauffeurs to get him here.
okay.
They were just running late.
He's got something he wants to do. All right, go ahead, Mr.
Your Honor, we had two different offers from the district attorney's office. One of which was dependent upon his completion of the inpatient rehabilitation program that he was attending when we were last here. Mr. Bearden has provided me with some documentation to indicate that he has completed that program. I'm going to share it with the district attorney's office for their satisfaction. And I can represent to the court that I think we can set this for a plea hearing and do that however, whenever time is convenient for the court.
Are you available on, we can come back. You available June 2nd, Mr. Adams? It's a Thursday. You're here on June 2nd?
I think so. It's fine.
Okay. All right, Mr. Bearden, glad you're here. That's good news. I didn't know you were here, and so we were talking about you like you weren't here. I thought you were still in the program, so that's good. All right, court will reset Mr. Bearden then to enter a plea on June 2nd. That will be at 9 a.m. Once you sign and get the yellow copy, you're free to go, Mr. Bearden. Is that all you have, Mr. Adams? Yes, thank you, sir. Mr. Ashmore, are you ready? Let's take up Ms. Fowler first. Okay, good. Ms. Fowler. All right, this is cause number CR 2333-334. And I believe that this is a status on the outpatient restoration. Go ahead, Mr. Ashmore.
Thank you, Judge. As you can see, Grace looks probably better than we've ever seen Grace look. Even back in the Zoom days, which I know were memorable at the Huddle House or whatever it was. It was a struggle, and Grace has been in the care. Her care provider is here. I met her this morning, Dr. Bashir. Say that right? Jennifer. And Judge, as I understand it, we're about halfway through the treatment program. So my request would be setting sometime in June, which will be closer to the 10-yard line, as I understand it. And then we can just see how she's about going further at that time. That'll also give me the opportunity, I apologize, confer beforehand. I hope you don't oppose. So we can see if we can come to a resolution.
Ms. Bashir, can you update the court on Ms. Fowler, any recommendations or needs that the court needs to address for Ms. Fowler?
Judge, I feel like we're halfway done with curriculum, medications. At this point, we don't need anything else from the court, just the additional 60 days.
Okay. So Mr. Ashmore is asking for about a 30-day reset, so we kind of get a status, just an update. Is there anything about setting it in 30 days that you think would be counterproductive for Ms. Fowler? Okay. All right, so about 30 days out, we're looking at June 14th or 16th, Mr. Ashmore.
Either is open at the moment.
All right, we'll go June 14th. Go June 14th, and that will be at 9 a.m. And it'll just be another status.
Thank you, Judge.
All right, Ms. Fowler, it's good to see you. I do agree with Mr. Ashmore. You do appear to be in a better state in your life right now. So I want you to continue to work with Ms. Brashear and comply with what she's asking you to do. If you've got meetings and appointments, it's very important that you make every one of those in order to get the maximum that you can out of the program. And the reason you're in that program is to help you, all right? And that program is going to be what helps you get to a point where you can resolve this criminal case and then get us all out of your life.
Correct.
Understand? So I think we're all working towards the same thing. You and I are working towards the same thing. It's a resolution.
Very much. It's a good program.
All right, good. Well, make sure you're taking advantage of it. Yes.
Is not on your docket today. She was charged with a case. With the misdemeanor was also filed upstairs. We agreed to allow them to plead to the case downstairs.
Pre-trial release, the delinquencies, deficiencies, they pay everything.
I don't know that.
I'll check that for you.
Make sure. In probation, I will, Judge. Civil Dixon. Yeah, Shannon Dixon. I'll hold it for you.
Yeah, hold it for me. She's in compliance, we can go and file it. If not,
Yes, Judge. Sir.
Mr. Ashmore, who are you ready on next?
Judge, let's do this Foley.
Lauren Foley, CR 21262. All right, I believe we're set for competency evaluation on Ms. Foley.
Judge, we have the competency evaluation from Dr. Ingram. It was filed April 4th. Either I ate it or missed it. It's possible. I'm not sure. I do have it now. The Assistant State's Attorney, Ms. Heisel, was kind enough to print me a copy. I'm not shocked that it finds her completely competent. I'm going to ask the state to not oppose and ask the court's indulgence for an additional either status or, because I think we're now with this, we can get into the meat and potatoes of whether we're going to try this case or not. Pretrial hearing or pretrial motions. I think we've already filed a motion for leave to file additional pretrials in the past. If not, I'd request the ability to do that because I would like some time to go through this. There are some things in here that I don't disagree with. There are some things that I do, knowing that this is a busy world, but the fact that she's identified as a him in this report gives me some pause as to the full validity of the findings, whether we move forward objecting to them or not. But this puts us in a position to negotiate further with the state. I've asked the state for that opportunity. Ms. Heisel has indicated the state's office won't oppose that. As the court knows, this is a child endangerment case, but what's unique about this is that Lauren Foley doesn't use drugs or alcohol, and those aren't the basis of any of these allegations. which I think makes her a candidate for some leniency, and I'd like the opportunity to continue to work on that regardless of her competency to stand trial. That's our respectful request, Judge.
Judge, state is unopposed to both the report filed by Dr. Hoover and the defense's request for a reset.
Like 30 days would be sufficient.
Yes, Judge. Same day. 14.
All right, court will set Ms. Foley for, I'm not sure where we were before.
I don't know if we'd actually gotten to a pretrial before the hearing on competency was presented.
So we had two pretrial hearings and a writ, and then we had two docket calls, January and March, and then a status in May, which is today. So we'll set it for docket call, and if there's any pretrial issues, you'll let me know.
Yes, Judge.
So we'll set this for June 14th at 9 a.m.
Thank you, Judge.
Judge, what's information is Dixon that you just signed, was never on the driveway, so she has not.
Okay, good. Thank you. Thank you.
So ready. Harris and Mr. Kaden Mitchell.
Alicia Harris, CR 21359. Is Ms. Harris a plea today?
She is. Sorry.
It's okay. You may. Sir. All right, Ms. Harris, if you'll raise your right hand. Ms. Harris, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
I do, Your Honor.
All right, you may put your hand down. Is your name Alicia Gail Harris?
Yes, sir.
And Ms. Harris, are you a United States citizen?
Yes, Your Honor.
Do you read, write, and speak English?
Yes, Your Honor.
And have you ever been diagnosed with any type of mental condition?
Yes, Your
What is that?
Honor. Anxiety disorder?
Are you currently on medication, undergoing treatment for that?
No, but I am in counseling.
You're in counseling. Do you believe that counseling assists you and that today you're in a rational frame of mind to understand the proceedings as they are proceeding against you?
Yes, Your Honor.
All right. And in this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you?
Yes, Your Honor.
Do you feel like you've had enough time to talk to him about your case and have all your legal questions answered?
Yes, Your Honor.
Anything about this paperwork, Ms. Harris, that you've read and signed today that you do not understand?
No, Your Honor.
Mr. Ashmore, do you believe Ms. Harris to be competent today?
I do, Your Honor. We've spoken at length about not only this case, the charges against her, the companion CPS case going on downstairs, her understanding of those proceedings as well as these. And we have conferred about her anxiety disorder, which she's currently not being treated for. It's not affecting her ability to make any decisions and be cognizant today or at any other time.
Thank you, Mr. Ashmore. All right, Ms. Harris, the plea agreement is that you're going to be pleading guilty to abandoning or endangering a child with criminal negligence, which is a state jail felony, which carries a range of punishment of not less than 6 months or more than 2 years in prison. That means if you are convicted of the offense and sentenced, that your sentence would have to be somewhere between that minimum to that maximum. Do you understand that?
Yes, Your Honor.
I see the plea agreement is that you're going to plead guilty to that allegation, and the state's going to be recommending that after you do so, that the court assess your punishment at 18 months in state jail, but then that the court should suspend that and place you on probation or community supervision for 3 years, order you to pay a fine, court cost, reimbursement fees. You understand that if the court approves this today, then the maximum sentence that you could get in the case would be 18 months in state jail prison, and you would be on probation for 3 years. That means that you're going to have to comply with all of these conditions that you signed here today. You understand that if you violate any of those and the state files a motion and brings you back to court and they prove it to me that you violated, they could ask me to revoke your community supervision and put you in prison anywhere from that minimum up to that maximum of 18 months.
Yes, Your Honor.
Understanding both of those things, do you still wish to go forward with the plea? All right, Ms. Harris, then how do you plead to abandoning or endangering a child with criminal negligence?
Guilty, Your Honor.
Are you pleading guilty to that, Ms. Harris, because you are guilty of committing that crime?
Yes, Your Honor.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, Your Honor.
All right, court accepts the defendant's plea of guilt. Mr. Ashmore, any objection to the state's evidence?
No, Your Honor.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor. I would just add in respect to the CPS case that Ms. Harris and her husband, the defendant, Mr. Harris. Yes, and that a very soon return of those children to their household. We hope that this probation plea will occur. CPS, thank you, like I said.
Good thing to decide on. Glad to hear that. Mr. Ashmore?
Nothing further, Your Honor. Thank you.
I'm going to review the evidence. I believe Mr. Hamner pled already in his case, is that correct? Recently.
Yes,
I recognize this evidence.
I believe it was 2 weeks ago. Your
2
Honor.
weeks ago. All right, court having reviewed the evidence finds that there is sufficient evidence to convict Ms. Harris of this offense. The court will follow the plea agreement reached between the state and the defendant. Court hereby convicts Ms. Alicia Harris of abandoning or endangering a child with criminal negligence. Court hereby assesses her punishment at 18 months confinement in the State Jail Division of TDC. Court will suspend that sentence and place her on community supervision for a period of 3 years. Order her to pay a $1,500 fine, $290 court cost, $535 reimbursement fees. Court finds that the state has agreed to abandon count 2 of the indictment. All right, Ms. Harris. That's good news that I heard from Ms. Heisel about your CPS case. All right. I hope that you will be as diligent on probation as you have been with your CPS service plan for your kids. Because your kids, if you get your kids back, it's going to be important that you be there for them. And this is going to be something that could prevent you from doing that. All right, Ms. Harris. I hope you're right. Pray that you're right. All right, Ms. Harris, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. Move forward with Deputy McLeod. She's going to take your fingerprint. After that, meet with the officers over here and they'll give you more.
digging.
You said you're ready on Mr. Mitchell?
Mr. Flores, and leave
Marshall Flores, CR 21-165 and CR 22-18. Mr. Flores, you're good right there. You're good right there. We don't need to work that hard. My eyes are still good enough to see it. All right, Mr. Flores is set for docket call in each case. Mr. Ashmore.
Judge, we have an offer of 12 TDC, 1245ing one of either case. I've learned some information recently with my client's conversation that I'd like to have additional time to talk to the state about. My client, as you can see, has a lot of medical issues, and we have been playing an epic game of phone tag trying to get him to Terrell so we can go through his discovery. And my request is, and I've conferred with the state, they don't oppose, to allow us an additional docket call to go through those, to see if we can come to some resolution with the state, short of putting somebody with a lot of medical conditions into the system. And that's our respectful request, Judge. I know we're out of docket calls. We're asking for one more so we can make all these things happen. Randy's been out in our Terrell office. I told him, just make the appointment. We will make it work. You need to come in and watch the videos. And that's our request.
Objection from the state. I show that this is the first setting for docket call on the CR 22 case. So the court will grant your request, Mr. Ashmore. We'll reset Mr. Flores. Do you need more time than June 14th?
I think we ought to just let's make it go.
Okay. Court will set Mr. Flores then for docket call on June 14th at 9 a.m. Mr. Flores, once you sign and get the yellow copy, you're free to go, sir. All right, Mr. Mitchell, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right. Let me put your hand down. Is your name Kaden Robert Everidge Mitchell? Sure. Mr. Mitchell, are you a United States citizen?
Sure.
Do you read, write, speak English?
Sir.
Have you ever been diagnosed with any type of mental condition? In this case, you are represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation? Do you feel like you've had enough time to talk with him about your case and have all your legal questions answered? Anything about this paperwork that you've read and signed today that you do not understand? You had to say out loud so my court reporter can take it down. Okay. And Mr. Ashmore, do you believe Mr. Mitchell to be competent today?
I do, Your Honor.
Have you explained to him his legal rights and both the advantages and disadvantages of a deferred adjudication plea?
Yes, Judge.
Do you believe he understands them?
I do, Your Honor.
All right, Mr. Mr. Mitchell, I see that you are charged by indictment with a third-degree felony offense of prohibited substance or item in a correctional facility. A third-degree felony in the state of Texas has a range of punishment of not less than 2 years or more than 10 years confinement in TDC, and a fine, an optional fine not to exceed $10,000. Do you understand that full range of punishment? In that case, if I were to approve the plea agreement, which is to defer a finding of guilt and place you on community supervision for 2 years, in addition to a fine and court costs and reimbursement, if I were to approve that and you were to go on probation, if you violated any of the probation conditions, you could be brought back for a hearing. And if the evidence proves to the court that you violated, the court could convict you of that offense and revoke your probation and put you in prison anywhere between 2 years up to the maximum 10. You understand that? Yes, sir. In your other case, you are charged by information with a driving while intoxicated second offense. That is a Class 8 misdemeanor, which has a range of punishment of not to exceed more than 1 year confinement in the Van Zandt County Jail and an optional fine not to exceed $4,000. You understand that range of punishment? Sure. I see that the plea agreement in your DWI case is that you would plead guilty to that. The state would recommend that your sentence be set at the maximum 1 year, but that you be then placed on probation for 2 years with fine, court costs, and reimbursement fees. Is that your understanding of both plea agreements? Yes, sir. Understanding the range of punishment, understanding the plea agreements, do you wish to go forward in both cases? Yes, sir. All right. Mr. Mitchell, at this time, I would ask you, how do you plead to prohibited substance or item in a correctional facility? How do you plead to driving while intoxicated second offense? Are you pleading guilty to each one of those crimes because you are guilty of committing each one of those crimes? Has anyone threatened, forced, or pressured you to plead guilty to either one of those, Mr. Mitchell? No, sir. All right, court will accept the defendant's plea of guilt. Mr. Ashmore, any objection to the state's evidence in either case?
No, Your Honor.
All right, state's evidence is admitted in each case respectively, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we rested on closing both cases.
From the defense?
No, Your Honor. Thank you very much.
All right, court's going to review the evidence briefly. All right, court's reviewed the evidence. Court does find that there is sufficient evidence to convict Mr. Mitchell. Court will follow the plea agreement in each case. Cause number CR 21403 as to the charge of prohibited substance or item in a correctional facility. The court hereby convicts Mr. Mitchell of that offense. Take that back. So the court will find that there's enough evidence to convict Mr. Mitchell of that offense. However, the court will defer a finding of guilt in that case and place Mr. Mitchell on 2 years community supervision, order him to pay a $2,500 fine, $290 court cost, and order him to reimburse Van Zandt County in the amount of $860. And the court will dismiss DA 2021-1179, a possession of controlled substance, penalty group 2 less than 1 gram under section 1245. The court will order this sentence to run concurrent with the sentence in CR 21406. As to that case, on the charge of driving while intoxicated second, the court hereby convicts Mr. Mitchell of that offense. assesses his punishment at 1 year confinement in the county jail. Court will suspend that sentence, place Mr. Mitchell on 2 years community supervision, order him to pay a $100 fine, $270 court costs, and $35 reimbursement. Court will also order this sentence to run concurrent with CR 21403.
Silver Dodge, told parked by Val's by the handicap entry.
Were you able to go out and verify that information? Okay. Is he not there? All right, Mr. Mitchell, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they carry out the terms and conditions of the sentence. I'm gonna have you step forward here with Deputy McLeish. She's gonna take your fingerprints. After that, you're to meet with the officers over here for more information, okay? All right, so you were saying about Jonathan Keenan, CR 2229, didn't make roll call.
Didn't make roll call, has exacerbated an injury that, as I understand it, stems from the incident giving rise to this charge.
Okay, so
I've told him to be here. He's texted me he is. He's said he's in a Silver Dodge outside.
we'll wait. We'll give Mr. Waddell some opportunity to see if we can get out there and confirm that for me.
May I be excused for a moment? I'll go assist and see if I can hunt him
Yes,
down.
please. Here's your last one, correct?
He's it, yes,
Okay, yes,
for
sir.
this morning.
Yes, sir. Mr. Schmidt, are you ready? Are you ready? Jeffrey Viramontes. This is cause number CR 21374. Mr. Viramontes, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Your name is Jeffrey Rodriguez Viramontes, is that correct? And Mr. Viramontes, are you a United States citizen? Yes, sir. Do you read, write, speak English? Yes. Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation? Yes, sir. Do you feel like you've had enough time to discuss your case with him, have all your legal questions answered? Yes, sir. Anything about the paperwork that you've read and signed here today that you do not understand? No, sir. Mr. Schmidt, do you believe Mr. Viramontes to be competent today? And have you explained to him his legal rights, and do you believe he understands them? I have. All right, Mr. Viramontes, I see you are charged by indictment. I see that now. You were charged by indictment with a second-degree felony offense of possession of a controlled substance in penalty group 2, 4 grams to 400 grams. However, the plea agreement today would be to a lesser included offense of a Class A misdemeanor. The judgment says 1244B. section?
It's ADG, which is class A misdemeanor under section 4.
It says class A misdemeanor under 1244B.
We'd like to change that to section 4.
Was that y'all's agreement?
It's full rate. It's mere conviction.
Right. All right, so you're changing the offense to PG2 less than 1 gram, and that is a state jail. All right. All right, Mr. Viramontes, I see the plea agreement is today for you to be prosecuted for the offense of possession of controlled substance, penalty group 2, less than 1 gram. Under section 1244B of the Texas Penal Code, which makes the degree of the offense a class A misdemeanor. See here that you're going to plead guilty to that offense, and the state's recommending that your sentence be assessed at 1 day confinement in a county jail, with you receiving credit for time served, being ordered to pay a $1,500 fine plus restitution plus court costs and reimbursement fees. In addition, the court would be dismissing an unlawful carrying of a weapon and a possession of marijuana, and you would be agreeing to a weapon forfeiture in this case. Is that your understanding of the plea agreement?
Yes, sir.
Is Mr. Viramontes paying any of his financial obligations today, Mr. Schmidt? Is he prepared to pay any of it today? Okay, good. All right, so Mr. Viramontes, the range of punishment for a class A misdemeanor is a maximum of 1 year confinement in the county jail and a fine not to exceed $4,000. Do you understand that full range of punishment?
Yes, sir.
Understanding the full range of punishment and the plea agreement, you still wish to go forward? All right, Mr. Viramontes, how do you plead to the lesser included offense of possession of a controlled substance, penalty group 2, less than 1 gram?
Guilty.
Are you pleading guilty because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
Yes, sir.
All right, court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to the state's evidence?
No.
State's evidence is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
No, sir.
All right, the court's reviewed the evidence. I do find sufficient evidence to convict Mr. Viramontes of this offense. Court will follow the plea agreement. Court hereby convicts Jeffrey Rodriguez Viramontes of the Class A misdemeanor offense of possession of a controlled substance, penalty group 2, less than 1 gram. Under Section 1244B, court will assess his punishment at 1 day confinement in the county jail. The court will give him credit for 1 day towards that sentence for time already served, orders him to pay a $1,500 fine, restitution of $180, court costs of $290, and reimbursement fees of $35. Court also dismisses under section 1245 unlawful carrying of a weapon, DA 2021-545, and possession of marijuana less than 2 ounces, DA 2021-546. The court orders the forfeiture of the weapon seized in this offense, namely a black Glock 23. All right, Mr. Viramontes, you're hereby remanded to the custody of the Benton County Sheriff so he can carry out the terms and conditions of the sentence. And have you come forward, be fingerprinted with Deputy McLeish. After that, you'll need to go get a copy of this judgment and then go down to the end of the hall on the left. You'll pay your $600 over here across at the district clerk's office and then go down to the end of the hall, meet with Ms. Bonnie LaPrade to set up your payment plan to pay off the rest. I'm sure Mr. Schmidt's probably told you that, but I'll tell you again. Dylan Hogan, CR 2224. Mr. Hogan, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can put your hand down. You are Dylan Anthony Hogan, is that right? Mr. Hogan, are you a United States citizen? And do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation of you?
Yes, Your Honor, I am.
You feel like you've had enough time to discuss your case with him and have all your legal questions answered?
Yes, Your Honor.
Is there anything about this paperwork that you reviewed and signed today that you do not understand?
No, Your Honor.
Mr. Schmidt, do you believe Mr. Hogan to be competent today? And you've explained to him his legal rights as they pertain to this case?
I have.
Do you believe he understands them?
I do.
I see that Mr. Hogan's been charged by indictment with a state jail felony offense of credit card or debit card abuse, and that the state's asking the court to allow prosecution to proceed under section 1244A, with the plea agreement being 61 days confinement in the county jail, credit for all 61 days, ordering Mr. Hogan to pay restitution, and then the state would be dismissing multiple number of debit card or credit card abuse cases. In addition, court costs and reimbursement fees. Is that your understanding of the plea agreement, Mr. Hogan?
Yes,
Yours as well, Mr. Schmidt?
that's correct.
And is Mr. Hogan prepared to pay restitution today?
Sorry, actually, had some associated charges. So he's just been recently released. So he's getting that's why he's going back to the desk. So at this point in time, he's
All right, Mr. Hogan, understanding the range of punishment in this case, if prosecuted as a misdemeanor, is your sentence cannot exceed more than 365 days in the county jail or a fine of more than $4,000. Do you understand that range of punishment?
yes, Your Honor.
Let's see. And so, Mr. Hogan, at this time, I want to ask you, how do you plead to credit card or debit card abuse, state jail felony prosecuted under section 1244A as a class A misdemeanor?
Guilty.
And Mr. Hogan, are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, Your Honor.
Do you understand if the court approves this today, you would be convicted as a felon in this offense?
Yes, Your Honor.
All right, Mr. Schmidt, any objection to the state's evidence?
No.
State's evidence is admitted. The court takes judicial notice of the defendant's judicial confession, and the court accepts the defendant's plea of guilt at this time. Anything further from the state?
Your Honor, I would just mention that there are a number of cases we are taking into consideration. Mr. Hogan used the same credit card a number of times. The restitution, this clause covers the restitution for all of those cases. And the county is obviously aware of them. So we are taking care of all of this in this one plea. It is our understanding as well that Mr. Hogan had spent an amount of time incarcerated, that he's not getting credit for it. So we are taking that into consideration.
Thank you, Mr. Roy. Anything further, Mr. Schmidt?
No, Your Honor.
All right, court's reviewed the evidence. I do find enough evidence to convict Mr. Hogan of this offense. Court will follow the plea agreement. Court hereby convicts Dylan Anthony Hogan of debit or credit card or debit card abuse under section 1244A as a state jail felony. Court will assess his punishment under that section at 61 days confinement in the county jail. Court will give him credit for 61 days time previously served. Court orders him to pay $1,500 restitution. I'm sorry, $1,500 fine, $229.20 restitution, $290 court costs, and $35 reimbursement fees. And the court will take into consideration under section 1245. All of the credit card and debit card causes of action as listed in the terms of the plea bargain referenced in the judgment. Mr. Hogan, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. In just a moment, I'm gonna have you come forward to be fingerprinted with Deputy McLeish. After that, I want you to go down to the court compliance officer at the end of the hall on the left, meet with her to discuss setting up the payment plan so you can pay back the fine, court costs, restitution, and reimbursement fees that you owe. Failure to do so will result in the court issuing a warrant for your arrest.
Yes, Your Honor. Thank you.
Shelby Joslin. This is CR 20126. Ms. Joslin, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you put your hand down. You are Shelby Nicole Joslin, is that right?
Yes, sir.
Ms. Joslin, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
You're represented by Mr. Richard Schmidt. Are you pleased with his representation?
Yes, sir.
Feel like you've had enough time to talk with him about your case and have all your questions answered?
Yes, sir.
Anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Mr. Schmidt, do you believe Ms. Joslin to be competent today?
Yes, sir, I do.
And you've explained her rights to her as well as the advantages and disadvantages of the deferred adjudication plea.
Yes, sir, in detail.
Is there anything? Let's see here. So this is a deferred plea to a straight third-degree felony, no reductions or anything?
That's correct, Judge.
Okay. All right, Ms. Joslin, I see that you are charged by indictment with a third-degree felony offense of possession of a controlled substance. Penalty group 1, greater than or equal to 1 gram, less than 4 grams. A third-degree felony carries a range of punishment of not less than 2 years or more than 10 years confinement in TDC. That's prison, and also a fine not to exceed $10,000. Do you understand that if I go along with approving this plea agreement today, wherein you're asking me to place you on deferred probation for 5 years, if during that 5 years you violate any of the conditions of your community supervision, the state could file a motion to convict you, adjudicate your guilt, bring you back in. If they prove to me that you violated through their evidence, the court could revoke your community supervision, convict you of that offense, make you a felon if you're not already one, and the court could then assess your punishment anywhere from that minimum 2 to the maximum of 10.
Yes, sir.
Understanding that plea agreement, understanding the range of punishment and the possible consequences, do you still wish to go forward?
Yes, sir.
All right, Ms. Joslin, then how do you plead to possession of a controlled substance in penalty group 1?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Does anyone threaten, force, or pressure you to plead guilty?
No, sir.
Court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to the state's evidence?
No.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Any further from the state? So the defense. Court's going to review the evidence. All right, the court has reviewed the evidence and I do find sufficient evidence to convict Ms. Joslin of this offense. The court will follow the plea agreement reached. The court hereby defers a finding of guilt, places Ms. Joslin on 5 years community supervision, orders her to pay a $1,500 fine, $180 restitution. Court dismisses a possession of marijuana less than 2 ounces in M19354. Court orders her to pay $290 court costs in addition to $85 reimbursement fees. Turn around the date. Ms. Joslin, do we have a drug problem?
I'm sorry, sir?
Do we have a drug problem?
No, sir.
I mean, you can tell me if you do. I mean, I'm not,
I've been sober for 3 years, sir.
it's great.
I attend at Crossroads. I attend on Wednesdays and Thursdays.
That, the recovery program with Larry,
Yes, sir.
it's great. That's a good program. All right, well, then this shouldn't be, if you're gonna be drug-free, then you're gonna stay clean and sober, then your probation will be a lot easier.
Yes, sir.
Still gonna be challenging, still gonna require you to be accountable and responsible for yourself through this whole time, but it's gonna be a lot easier if you're not high.
Yes, sir.
All right, Mrs. Joslin, you hereby remain into the custody of the Van Zandt County Community Supervision Corrections Department so they can carry out the terms and conditions of the sentence. I'll have you come forward to be fingerprinted. After that, you can meet with the officer over here and they'll give you more information. Robert Gerard, 2267. Mr. Gerard, I called your name at 9 o'clock and you weren't here. Mr. Schmidt asked me to not find you, your bond is sufficient, and put you in jail. So after this hearing, you can thank him for that. Okay. Mr. Gerard said, I got him set for arraignment, but
You know,
did that last time, didn't we?
I talked, yeah, I can't recall. I slept since then, I think. Jail call. Evaporated the recollection of it, so we are set for arraignment. And I did not, I checked, I didn't find a waiver on them, so it would have had to have been in person.
Have you made an appearance with Mr. Gerard before? I remember Mr. Gerard being.
I think that I addressed the bond issue, but I don't recall, and that was ended up being agreed.
Okay. Well, let's go ahead and arraign him. Do you have a copy of the indictment with you? If not,
We've met together, my office judge, and gone through the indictment. His name is spelled correctly, he understands what he's charged with. We waived the formal reading, enter a plea not guilty. Obviously, it's set the matter for the pretrial.
all right, court will find that Mr. Gerard has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record. We will set this matter for pretrial.
Yes, Judge, and before the court sets it, I've been in contact with Ms. Curry over this case. There's a couple of issues that she and I have already discussed regarding pretrial matters. One of those is going to require me filing a motion requesting ex parte funds from the court so that we can get some testing done. Ultimately, I can tell you that the likelihood of having that completed by the 16th of June is probably 0. So we'd ask at least to start to get that July 5th docket day for the pretrial. I think Mr. Waddell has met with him this morning.
All right. All right, the court will set Mr. Gerard then for pretrial on July 5th. That'll be at 9 a.m. And Mr. Gerard, I do show that you do have other business in the courthouse. I show that there's a misdemeanor case where you're delinquent $1,000. So I need you to go down after you get this notice, the yellow copy, go down to the end of the hall, meet with the court compliance officer, and talk about what y'all can do to resolve what you owe. Otherwise, you may end up getting a warrant for your arrest, capious profile. You may. All right, Ms. Pullings. This is a sanctions. All right, this is a sanctions court hearing for Andrea Cherie Pullings. Ms. Pullings, your analysis test was negative, so that's good news. I have concerns on your probation. I'm getting reports from your probation officer that you may not be complying. Says that you failed to provide job searches for your employment. They believe that you're not motivated to comply with your probation.
It's not that my daughter was born with a heart and kidney problem. I'm in the hospital 24/7, so I don't have help. They just started my benefits today for me to get child daycare so I can get help. Then I have to find a daycare that's gonna help me out with her, because if she don't take her medicine, she can die.
Understand that. You understand that you've got a lot of things that you've got to get done while you're on probation, and if you don't, you're looking at going to prison. You understand that you're on deferred probation for abandoning or endangering a child, and you got all the way until October of 2023. And if you don't get these things done, if you don't get your money paid, if you don't get your probation worked, you haven't done any of your probation hours. Zero. You were ordered to do 170.
And I told them, like, when I was supposed to do that, when I agreed to that, I was pregnant. I went in labor, so I couldn't do it.
No, I understand. I'm just telling you, your probation is either going to get revoked or you're going to get extended for a couple of years. And that's going to be it's going to be a burden on you. I'm just telling you, you've got a lot you've got to get done. And I understand that you're dealing with your daughter and those things, but that's something else you're having to deal with. You don't get to just stop one because of the other. I don't get to stop work when my kid gets sick. I don't get to stop all my other responsibilities in my life when my kid's got an important test at school and I've got to focus on what he or she is doing. I don't get to stop and just do one thing at a time. Unfortunately, neither do you.
I understand it, but I love my child more than this. I ain't even gonna lie. I didn't want my baby to die. I didn't even know she was born with a condition.
I understand.
I found this out after she started choking one day, and I rushed her. She couldn't breathe, and they told me that, like, I've been literally in the hospital in and out, getting her blood drawn back to back to back. Not only her, my son is sick like that too. I ain't even took him to the doctor. I haven't went back myself.
I understand. And I'm not asking you to place your child below your probation. I'm telling you, you're going to have to learn how to deal with both at the same time, just like everybody else who's not in jail.
That's why I signed up for help, like for business to help me and my child.
That's good. That's good. But I'm saying, if you say probation, all this, I don't care about you, I'm going to focus 100% on my child. What's going to happen is you're going to be taken away from that child. And then what is she going to do? Then who's going to be caring about her? Who's going to be providing for her? Who's going to be making sure that she's okay? It won't be you, because they're not going to let you have your baby in the jail. That's what's going to happen, Ms. Pullings. I'm just trying to get your attention. I understand your mother's love for a child, but you better start realizing that if you don't do what you're supposed to do, you're not going to be her mother. It'll be somebody else. You'll be locked up for 2 years. It'll be somebody. She'll know somebody else as her mother. All right. I'm trying to get you to understand what's coming. I would rather do it today. I'd rather you get upset and emotional today than me say, Ms. Pullings, you're going to prison. and then you cry every day for 2 years. You understand?
Yeah.
I hope so. There are a couple things I need you to do. One of them you've already done. You passed your drug test. That's good. I want you to do a mental health evaluation for me. All right. Probation officers are going to set that up for you. I want you to agree to do that. Okay. There's money obligations that you're going to have to figure out through a job, through benefits program, through friends, family. You're going to have to pay your probation fees. You're going to have to pay what you owe for your court fines and fees every month in order for you to be through on time. And it's a lot. You have to pay $115 to probation every month. You have to pay $160 to the court for your fines and court costs every month in order for you to be done in October of 2023. Every month that you don't do that or you fall behind is another month that either you're going to get extended or it's going to put you further behind. That's going to lead to a revocation and you coming back to the court and going to jail or prison. And you got to do your community service. You're going to have to figure that out. You got to get a babysitter. Somebody's going to take care of your daughter and your son for at least 12 hours a month. It's just 12 hours. 2 days, 2 half days, however you do it. You're going to have to get that done. This is part of adulting. This is part of being a parent. Okay? So these are things that I'm going to order you to do and these are things that we're doing not to punish you. These are things that we're doing to try to help you so you can make it. I don't lecture people if I'm about to send them to prison. I just send them to prison. So be thankful that you're getting the lecture today. These are things that you have to do in order to stay out of prison. These are things we're going to give you an opportunity to do. All right. So these are the things that the probation officer is going to discuss with you, and I'm going to sign an order for your mental evaluation. And these other things, I'm going to reset for another court date. I'm going to give you 30 days, and then I want to see some kind of progress towards them. If you come back and you haven't done anything, then we're probably not going to have a lecture. Okay? All right? All right, come over here and meet with the probation officers, and they'll give you more information. I'm sorry, Miss Pullings, I'm going to reset you for June 14th. And so we're going to fill out a form. You can go ahead and go back there with the officers. Sure, we'll bring that to you and get a. Mr. Ashmore, if you can see me and hear me, I'm ready to. There you are. Are you ready to proceed?
We are, Judge.
Okay, can you guys see and hear me okay?
Yes, Judge.
All right, this is cause number CR 2229, State versus Jonathan James Keenan. We're set for pretrial. Go ahead, Mr. Ashmore.
Judge, we don't have any pretrial motions pending before the court. We're not anticipating at this time to file any. We may have a need for some further conference with the state. I've been informed about some communications between the alleged victim and my client. I'd like to gather those and present them to the state, but I think we can do that in a docket call. My client's here and present, even though he wasn't here at roll call. He's injured his back. It's my understanding that some of those injuries were caused by or made worse by the incident giving rise to this case. But here he is. As the court can see from this video, we're on Capitol Street by the handicap entrance outside of the courthouse.
All right, how much time do you need on pretrial, Mr. Ashmore?
I think we'll be ready on 6/14, Judge.
All right, court will reset Mr. Keenan then for pretrial on June 14th at 9 a.m. Mr. Keenan, it's my understanding that you told my coordinator that you are going to the doctor today for your back. Is that correct?
Yes, sir.
Okay. I want you to provide documentation of your visit to the doctor to Ms. Tabraham, my coordinator, and to Mr. Waddell before 5 o'clock tomorrow. All right. All right. Once you sign and get the yellow copy, then you're free to go.
Judge.
All right. Thank you, Mr. Ashmore.
Yes, Judge.
All right. Let's look through this. Names called. Let's go to page 3. No. Page 5. Sorry. 5 has Justin Smith at the top.
Yes, sir.
Justin Lee Smith. Sergio Villarreal.
Villarreal. Okay.
Page 7. Michael Todd Musselwhite. Page 8. Alyssa Villarreal.
Got her twice.
Brandon Robertson.
Got him.
Dusty Rhodes.
Got him.
That's all.
Okay.
All their names loudly distinctly 3 times in the courthouse. If there's no response, what's judgment I size, alias, KPS, bond forfeiture.
Judge, we appreciate the appearance of Christmas Judge. Today's docket call.
It doesn't matter. That's like. Shine and just a few weeks ago, I did a check on it. It's been a bit in line. So you go check.
What did you get verified with Sergio? Was he gonna drive from Waxahachie? The bondsman.
Not without checking, not without action, because every day is different. You want me to go over there?
So what did she get?
She got a car here, is it one? Is it in?
If he does show up.
Yeah, I mean, just.
Well, if he comes this afternoon,
I can go and run over to.
but he needs to come see me. If he does show up.
Because we have our open house in Terre. It's only been over a year. Yeah, so I was scrambling. Is that on Zoom or?
You can be at the jail. Dr. Portman will be.
On Zoom, then I'll go to the jail.
All right, we ready? All right, Deputy McLeish, did you call the names Dustin Lee Smith, Sergio Villarreal, Michael Russell White, Alyssa Villarreal, Brandon Robertson, Dusty Rhodes? Did you call their names loudly, distinctly 3 times in the courthouse? No response. Their names being called, not present. Court is ordered. Court hereby issues judgment nisi alias capias and forfeits the bond of each one of those individuals. That completes this morning's docket. Court will stand in recess until 1 p.m.